Constitutional Court Belgium. The Constitutional Court Dutch, Grondwettelijk Hof, French, Cour constitutionnelle, German, Verfassungsgerichtshof plays a central role within the federal Belgian state. This is a judicial court founded in 1980. Its jurisdiction was augmented in 1988 and 2003. History. Founded as the Court of Arbitration, the court owes its existence to the development of the Belgian unitary state into a federal state. The original name that had been given to the court already says a lot about its mission, which is to supervise the observance of the constitutional division of powers between the federal state, the communities, and the regions. The Court of Arbitration was officially inaugurated in the Belgian Senate on 1 October 1984. On 5 April 1985, it delivered its first judgment. In May 2007, upon a change of the Belgian constitution, the court was renamed Constitutional Court, as this name is more in keeping with the actual jurisdiction of the court. Jurisdiction. Since 1988, the court is also responsible for supervising the application of some particular articles of the Belgian constitution, such as the principles of equality, non-discrimination, and the rights and liberties in respect of education, the Articles 10, 11, and 24 of the Belgian Constitution. A special law of 2003, this competence was expanded to the Section Roman II Articles 8 to 32, and the Articles 170, 172, and 191 of the Belgian Constitution. The court is therefore developing into a constitutional court. The court has two modus operandi. Each stakeholder can, within 6 months of publication of a law, decree or ordinance, go to the court in order to have the law, decree or ordinance annulled because of a breach of the aforementioned articles of the Belgian Constitution or because of a breach of the division of powers between the federal state, the communities, and the regions. When the court decides to annul a law, decree, or ordinance, it counts erga omnes for all persons. The second modus operandi of the court are the preliminary issues. If a question comes up in a particular tribunal about the correspondence of laws, decrees, and ordinances with the rules laying down the division of powers between the state, the communities, and the regions, or with Articles 8 to 32, 170, 172, or 191 of the Constitution, that tribunal must address a preliminary question to the Constitutional Court, as the court has the exclusive competence of interpreting the Constitution and the competence dividing rules. When the court finds a breach of these articles, it will pronounce its decision inter partes, meaning the ruling has effect only between the parties of the specific case. Such a judgment, however, has great moral value and will force the Parliament which made the targeted law, decree, or ordinance in question to amend it. Judges. The court is composed of 12 judges, 2 linguistic groups of which 6 Dutch and 6 French speakers. One of them must have an adequate knowledge of German, appointed for their lifetime by the king in practice, the federal government, within a list of candidates provided by the federal parliament. The list to fill a vacancy contains 2 candidates proposed alternately by the Chamber of Representatives and the Senate by a majority of at least 2/3 of the members present. Each linguistic group is composed of 3 judges with a legal background and 3 judges who have had at least 5 years' experience as members of Parliament. Candidates must be at least 40 years of age. The judges may hold office until they reach 70 years of age, when they retire from the bench. Currently, only 3 of the 12 judges are female. According to a change in 2014 to Article 12 of the special law, the membership of the court needs to contain a measure of gender equality. At least 1/3 of its membership needs to be of the opposite sex. Until that number is reached, new appointments are legally obliged to be of the underrepresented sex. However, this obligation has not been respected when Mitchell Pax was appointed in 2018. Composition. The court is currently composed as follows. Judges background. Dayat B. 1951 is a former judge at the Council of State. Lithian B. 1959 is a former member of the Chamber of Representatives 1991-1999 and minister in the Walloon government 1999-2004. Jayat B. 1958 is a former member of the Chamber of Representatives 1995-2013. Kerbash B. 1972 is a former member of the Flemish Parliament 2014-2019 and the Chamber of Representatives 2019. Lavrison B. 1956, a law professor and former judge at the Council of State. Layson B. 1952, a former referendaris law clerk at the Constitutional Court. Merks van Goey B. 1951 is a former member of the Chamber of Representatives 1985-1995 and of the Flemish Parliament 1995-2007. Mowerman, J.P. B. 1952 is a former member of the Chamber of Representatives 1995-2001. Mowerman, J.B. 1958 is a former member of Parliament, Federal Minister of Economy, Energy, Foreign Trade and Scientific Research 2003-2004, and Vice Minister President of the Flemish Government and Flemish Minister of Economy, Scientific Research, Innovation, and Foreign Trade 2004-2007. Nihal B. 1961 is a former judge at the Council of State. Pax B. 1959 is a former judge at the Council of State. Pieters B. 1956 is a former member of the Belgian Chamber of Representatives 1999-2003 and the Belgian Senate 2010-2014. Former judges. Plus denotes that judge served as president of his linguistic group. Procedure. An appeal to cancel a law, decree or ordinance may be submitted to the court by the Council of Ministers, by the government of a community or region of Belgium, by the presidents of the Chamber of Representatives, Senate, and the community and regional parliaments, at the request of 2/3 of its members, and by any person who can demonstrate an interest in the cancellation. In other words, the law, decree, or ordinance must be harmful to the party submitting the appeal. Cases before the Constitutional Court are normally heard by a panel consisting of 7 judges that decides by majority. Cases can also be heard by the whole court if either president so decides, or if at least 2 judges of the ordinary panel of 7 judges so requests. If cases are heard by the whole court, the court cannot rule unless at least 10 judges and an equal number of Dutch and French-speaking judges are present. In this case, if the votes are equally divided, the president of the court has a casting vote. The appeal must include the subject of the appeal and must be motivated. The party submitting the appeal can also request that the law, decree, or ordinance in question be suspended pending a final ruling by the court. A law, decree, or ordinance can only be suspended when the application of the law, decree, or ordinance in question could incur serious and difficult to repair harm to the party submitting the appeal.